Hi, everybody. It is January 2019, which means we are coming back to you with another exciting installment of California employment law updates. So my name is Galia Aharoni. I am the founding attorney at Aharoni Business Law. We are an Oakland-based law firm that helps small businesses with business law, employment law, and intellectual property law, like trademarks. And we do this video every single year, either as a video or a webinar or something, because it's really important. It's a boring one, but it's really important, and it's important for employers, of course, but also employees to know what everybody's rights and responsibilities are. So that's why we make sure to do this one every single year. Employment law is changing constantly. There is a overlapping mix of federal law, state law, and local law, and it's really good to have a resource like a lawyer to give you proactive updates because things are constantly changing, and a lot of the times we see people breaking these rules because they don't know what the rules are. So at the very least, watch these videos in January, get up to speed because most of the changes happen in January, but they do happen throughout the year, mostly January and June. So keep an eye out for local employment law changes and California-based changes if you have employees. Also remember that some laws kick in when you have a certain number of employees, so keep an eye out for that too, especially if you're hiring pretty quickly. We'll share our contact information at the end, so feel free to email us or contact us via our website if you have any questions anytime. So just to note that all the laws I'm going to be talking about are California-based laws, and they have started January 1st, 2019, unless we say otherwise. So let's just jump right in. One of the biggest changes for employment law in 2019. First one you probably already know about. There's yet another minimum wage increase this year in California, and that's because we have a law that's increasing it every single year automatically until 2023. So right now, statewide minimum wage for companies that have 26 or more employees is $12 an hour. It is $11 an hour if you have 25 or fewer, and that's going to keep going up again every single year. There are lots of cities and counties that have their own minimum wage that's even higher than this. So 25 cities this January increased theirs, including San Francisco, Oakland, San Jose, LA, San Diego, and a lot of other ones too. So if you have any doubt, check your local county website, city website, and make sure you're paying everybody minimum wage so you don't get sued. And obviously there's also should be a local minimum wage poster, a state one and a local one that you are required to put on your wall in your office. So make sure to replace the minimum wage poster with the most accurate one as well. So the next big change we have, there was a whole bunch of new laws that came down this year in California having to do with discrimination, harassment, and retaliation. And most of this was based upon trying to protect the victims of sexual harassment and sexual assault, and giving them a little more equal footing in the workplace and in court. So the first one we have here is extra protection for accusers and victims of harassment, sexual harassment, for defamation. So the problem that was happening was that employers and victims were afraid to to publicly say they had been harassed because the person who was accused of harassment could try to threaten them and bring a claim for defamation in court and say that they're sullying their reputation. So now with this new law, employers and victims are now better protected from liability for defamation claims, and so hopefully they won't be afraid to speak up if something happens. So one part of this is that they aren't going to be liable for damage to the accused reputation as long as the claim is being brought based on credible evidence and without malice. Also, there's an extra layer of protection between the employer and the victim or witnesses. Those communications are now more protected as well if an employee brings a claim at work. And an employer, if somebody calls and asks for a reference, an employer is now allowed to reveal in a job reference whether the person is eligible for rehire at their company due to a finding that they were engaged in sexual harassment. So that gives a bit more protection for people who are in the position of bringing a claim against somebody. So the next one related to sexual harassment here is about confidentiality clauses in settlement agreements. So the history of this one is that it became a kind of common practice in a scary way that the harasser would try to silence a victim of harassment by basically throwing money at the claim and trying to settle it out in exchange for a promise that they won't say anything about the harassment or assault in the future. So things like this have become really well known in the media now. You know, Harvey Weinstein is a good example of this happening, but it's happening, you know, more and more. We're hearing about it from politicians and other, you know, big shots, but also I think it's been happening. There's a history of it. So the state is trying to protect victims a little bit in this situation. So they're more free to come forward publicly about their abuse and won't be as afraid of getting sued by their own harasser. So now if there's a lawsuit about sexual harassment or assault or discrimination, you can no longer include a confidentiality provision in the settlement agreement that prevents disclosure of factual information. So, except for things like the victim's identity, you is exempted from that. So that will even the playing field a little bit. Another related law to this is that you can no longer have a provision in a contract or a settlement agreement that prohibits testimony about criminal conduct or sexual harassment in any sort of legal proceeding. So, so those are some big changes as far as just legal proceedings and what you're allowed to put in settlement agreements. The next one here is that employers can't require an employee to waive claims and sign a non-disparagement agreement in exchange as a requirement for work. So this is an update to FEHA, the California Fair Employment and Housing Act. You can't now require an employee in order to to give them a bonus or a raise or as a condition of new employment or continued employment. You can't require that they agree not to sue you or bring a claim against you for discrimination. And also, you cannot force them, likewise, to sign a non-disparagement agreement that would otherwise prevent them from disclosing information about unlawful acts in the workplace, including sexual harassment, but not limited to sexual harassment. So this doesn't apply to things like severance agreements or settlement agreements. And there are other small changes as well that affect the actual how the lawsuits are going to be handled. But those are kind of the big ones going on here about discrimination, harassment, and retaliation. So if you're an employer, hopefully these issues never come up with proper training and prevention. But those are some changes that the goal was to try to equal the playing field a little bit for alleged victims of sexual harassment and abuse. So related to this, another one that the state changed, big one, that applies to a lot of employers. There's a new requirement for harassment training. So there used to be a law about this that applied only to bigger companies, but now all employers in the state of California who have 5 or more employees are required to provide sexual harassment training to all of their employees before January of 2020. If you have, it's 1 hour training required for all of your employees, 2 hours training required for supervisors. So the law now is that this training has to be done within 6 months of hire for new hires or promotion, and every 2 years after. So this is going to be a really big change for a lot of companies. And also don't forget your temporary workers and your seasonal employees, because they also count as employees for this that require training. So within 30 days of hire or within 100 hours worked for temp and seasonal, still have to give them training. Do know that there are rules about what you have to cover in this training and who is allowed to give this training. It has to be given by a qualified person. It can't just be a random untrained supervisor at work. So you can have a lawyer come do this for you. There are also a lot of good online trainings from reputable sources like California Chamber, and they provide some online training for a bit cheaper than probably a lawyer will do it. It's a little more flexible, but make sure you have a professional come and help you with this. All right, so our next topic here is the tweaked/new independent contractor test. So you might have heard of this new test. It's from a case called Dynamics, and some people pronounce it Dynamex. So it broadened the scope of the classification of independent contractors and made it actually harder for people to be classified as contractors instead of employees. So this applies to a lot of companies throughout the state of California. The general test is a 3-part test. First is that the contractor is supposed to be free from control from the client. you're really just supposed to give them the end product, not really be able to tell them how to do their job and when and what they're doing. The next factor is that the contractor is supposed to perform work outside of the usual course of business. So if they're doing things that you do it on a daily basis as a key part of your company's work, it's probably not okay. And the third one is that the contractor is supposed to be customarily engaged in an independent trade, which mostly means they should hopefully have their own independent business and business cards and website and all of those things. And you need all three of those satisfied to have that person count as a contractor. So keep in mind that every other agency still has its own rule, the old rule, which is still, in favor of people being classified as employees instead of contractors, but not quite as broad as this. The future of this law is also unclear because a lot of people are protesting it. It's kind of going to reimagine the face of business in California, especially the freelance economy. So we'll see how it plays out and how it ends up being applied in the future. But if you work with independent contractors, I encourage you to look into this rule or talk to a lawyer and do some research. I literally do a whole hour-long conversation just about this. It's a important and complex issue. So if you want to know more, please research it. We do have an article on our website, which is listed here, aharonibusinesslaw.com/dynamics-rule for more information. But it's an important one, so keep an eye out for that if you work with contractors. The next one is just a list of employment posters you are supposed to post. If you have any employees at all in California, you are required in some public meeting space where all your employees have access to, have all of these required employment posters up in that office. So there are posters that are required legally from the federal government and the state government and your local governments. So these are a few that have changed, including obviously California minimum wage, but there's also new notices and updates for EDD and state disability pamphlets and wage orders updated, all of those things. And these get updated at least every January. Some of them get updated often, usually later on in the year. Sometimes they do too. So all of these are available for free online at the different agencies' websites. But I find that it's often a lot easier to just order from something like the Cal Chamber, an all-in-one poster. You put in your city or your state, and they will give you kind of an all-in-one that covers most, if not every single one of the posters. And if you sign up for the extra updates, they will also update you every time there's a new one. So no affiliation with that, but it's an easy way to get that done. So make sure that your posters are updated this year and every year, and that you have some way of knowing when to update them. So there's a few miscellaneous ones. I won't go into as much detail about these because they apply to fewer people. But if you think these might apply to you, do a little research or call a lawyer and find out more to see if you need to change anything that you're doing in your business. So the first one is about paid family leave. Now military families can collect paid family leave benefits if they take leave for military-related purposes. So in other words, if someone's an immediate family member of someone who's in the military and there is an official military event such as a military ceremony or changes to childcare, or even you should be able to do it to spend time with a service member when they're on their rest leave. So you are able to collect benefits when you're on that leave. So it doesn't guarantee the leave itself. It doesn't provide the leave, and it's not job protected. But if you were able to take leave from your company, it provides those benefits. So it only applies to what they're calling qualifying exigencies related to active duty status. So do look into what situations it would apply and whatnot. But that's something that could be really beneficial for some people. The next one is a new lactation accommodation. So if you have an employee who is a parent who is breastfeeding, the employer is now required to provide a lactation area that is close to the worker's work area and is not a toilet stall. So there is a limited exception for if this causes undue hardship for your small business, but generally this is something that a lot of employers are going to have to now provide for their workers, and it can't just be a toilet stall. So the third one you may have heard of already. It's now a requirement that there's better gender representation on Boards of directors. So this only applies to publicly held corporations who have principal offices in the state of California. So that's not, it's probably not a lot of small businesses that it applies to in California. The requirement now is that these big companies have to have at least one female board member by the end of 2019. Depending on the board's size, they might have to add up to 3 female board members by 2021. The consequence of not doing this is financial penalties on the company. So hopefully all these companies will have women on their boards already and it won't be a problem. The last one here is workers' comp liability. This just extends employers' liability for workplace injury reporting violations. The penalties have been extended from 6 months to 5 years out. So hopefully that doesn't apply to anybody either and shouldn't change anything day to day. But just make sure you're all up to date on your workers' comp procedures. There are some industry-specific ones I wanted to mention that I'm not going to go into detail about again, but if you are involved in any of these industries, maybe do some research or contact a lawyer to get more information to see if you need to change anything. So the first one is talent agencies also have to provide some sexual harassment prevention training now. There are some overtime changes for agricultural employees, some claim changes for construction industry. There are changes for petroleum facilities about rest breaks, and also for trucking companies, commercial trucking and port trucking. The last one here is about human trafficking. There are already a bunch of companies and industries that are required to provide posters about human trafficking. And this now is adding a requirement for certain employers who have more than 20 employees and are in certain industries like rail or bus station employees or hotels to also have training about human trafficking, what it looks like and how they can identify it and what to do if they suspect it. So one last thing that's a really good thing to do now that 2019 has started is to make sure you're also complying with all of the law changes that happened in 2018. And there are also a little bit of tweaks that happened in 2019 to clarify the 2018 law. So the first one is the salary history ban. So you probably, hopefully know if you're an employer that you're not supposed to be asking applicants what they have previously been paid at other jobs. So there's a new law that just clarified that you can ask about salary expectations. So you can't necessarily say how much were you making, but you can say what are you hoping to make if we hire you for this job. And there are other changes that clarify some other duties there as well. But that's one clarification that will be really helpful. The next one is the strict rules that were just enacted last year about considering conviction history of an applicant during hiring. There are a lot of restrictions now about when and whether you can ask whether somebody has a criminal history. So for now, there is a clarification that about criminal background checks. You can only consider sealed or expunged convictions if that particular conviction would legally prohibit you or that employee from holding that job. So make sure you're complying with both of these laws from 2018 moving forward, and there's a little more clarification. So what are you going to do in 2019 to make sure you're up to date on everything? First of all, make sure you're going to start to provide your harassment training for everybody if you have 5 or more employees. Beginning of the year is a really good time to review and update all of your employment policies, all of your procedures, all of your posters, and give a look at your handbook and update everything that needs to be updated. An outdated handbook is almost worse than not having a handbook at all. And if you don't have a handbook, now's a good time to get one, because that's really it's to protect the employee, but also especially to protect the employer. So everybody knows what the policies are and everybody knows how to handle something if something goes wrong. So please do that now before it's too late. Do a little digging, make sure you understand how paid family leave works, provide a lactation area if that applies to you. And now's a good time to have an expert audit your employment policies and procedures and handbook if they haven't been looked at for a while. So with these kinds of things, prevention is a lot easier and a lot cheaper than a lawsuit. So take these issues really seriously, especially the new harassment laws. Plan ahead to prevent them. It's a lot easier to prevent than to deal with after somebody makes a claim. And know how to deal with it if it does come up. So if you have any questions, you need any help, you want some clarification on anything, this is our contact information. We're at Aharoni Business Law. Our phone number is 855-414-4529. Office line is office@aharonibusinesslaw.com. And you can also contact us directly through our website. So I hope that was helpful, and I hope everybody has a successful, prosperous new year, and everything goes well with your employees and you don't get sued. So have a happy 2019, everybody.